Let me just get right. We are live now, so bear with. Okay. Good evening, everyone. Just trying to get my paperwork in order.
Okay.
Right. Just before we start, I'm going to do a disclaimer. I need to do a slight disclaimer here. So what you are about to hear is not intended to be legal advice. So please do not accept this as legal advice. If you are unsure about anything, seek advice from a bar registered solicitor. This podcast is for entertainment purposes. I don't want it to get taken down for what we are going to speak about. Good evening. It is now Sunday the 22nd of September, 6 o'clock in the evening. Thank you everyone for joining. It's going to be a very interesting discussion because this is the journey of one lady's experience with the mortgages and challenging it and everything. So in a second I'm going to introduce her, but again I have to say this is not legal advice. Please do not stop paying your mortgage without, you know, being sure you know what you're doing. This is not a podcast to tell you to stop paying your mortgages at all. But what this lady is going to speak about is the things that she's uncovered behind the scenes. So tag people that you think will benefit from this podcast tonight. The lady's not going to be showing her face. We're going to do it through a phone call, and we're just now going to do a sound test. So I just need everyone to sort of, or not everyone, I need someone, but I'm sure everyone's going to jump on there. James and Lisa, can you just give me, Lisa Clow, can you just give me a thumbs up that everybody can hear me? And can you just speak, please, so that check that everyone can hear you too, Shell.
Hi everyone. Can everyone hear me okay?
You are loud and clear at my end. Just want to make sure that you are loud and clear at everybody else's end. Okay, perfect. So just give me the excellent. So all good. Everyone can hear. Fantastic. So
Great.
I'm going to be looking at the laptop. I'm going to be speaking to Shell, and we're not going to disclose any personal details. We are not going to be mentioning names of anything or anyone. And I think you'll find this podcast, well, I found her journey very eye-opening. A lot of detail. She's done a lot of research. I think you guys will enjoy this. So if there's anything you don't understand, please let me know. And we're going to take questions as we go along. Shell's happy to stop and answer any questions, as long as please don't interrupt for unnecessary questions. We're not going to give out personal details or locations. Right. Please share. I'm shadow banned, hugely shadow banned. People can't even find me on Facebook. When I say to people like, you know, Laura Nina on Facebook, it doesn't show up. That's how shadow banned I am. So if you want to tag people, you want to share it, this, that and the other, please do that. Right, okay, gonna start. Good evening, everyone. So glad to have you here. I am here with a lady who I'm going to bring on now, who is an absolute rock. She's an amazing woman. She's really given a lot of her time to studying and to fighting her mortgage. So I'm going to pass over to Shell, and I'm just going to ask you, Shell, what started you on this journey? Now, we spoke to her before. I think it was a year, maybe a year and a half. Look, everything to me is the other day, but I'm sure it was either a year or two ago that we actually done a podcast together. Yeah, what started you on this journey?
Right. Well, I have been in my property since 2004, and I've never ever missed any payments. I was never in arrears, nothing like that. In fact, it was an offset mortgage, and it was always overpaid right up until the lockdowns of 2020, 2021. Like a lot of people, I've been self-employed for 30 years, and was common with a lot of people, you know, it was being told you couldn't work in lockdown and not being financially compensated for that. The help I was getting didn't even cover half of the mortgage payments, and because of that, I requested a payment holiday for 3 months, which was then extended to a further 3 months after that. Now, during that time, I started studying about mortgages. I already knew quite a bit, and I probably started looking into it maybe over the years, but more probably a couple of years before that. During that time, I learned about securitization, and I started delving into the whistleblower document side, and those documents are not easy to find. Because if you do a search on securitization, or what I did was look up, what was it? Securitization fraud by the banks, and I started finding all sorts of stuff, especially out of South Africa, in the US. So I did get a lot of my information from the US, and one site in particular, which is beyond dispute. It's absolutely 100% follow that, and every single thing that I've seen through that is ended up, I've kind of tested it all, and it's all just been like clockwork. So you know, the whole thing, every single point.
Which site is that?
It's actually Neil Garfield, who is, if you check out his credentials, he's a 50-year trial lawyer and investment banker, a securities analyst, securities broker, a court-approved expert witness on securitization, and credentials are all there. His stuff goes back many years. He actually died last year, age 76. Now, I can give you the site for that. It's livinglies.me, so that's ME. Or there's also the Neil Garfield Show, which is on blogtalkradio.com. Now, there's 345 podcasts on there, and there's over 180 hours worth of podcast content that I've gotten a lot of my info from, as well as older interviews, podcasts, and information dating back probably the last 16 years. I also got a lot of information out of South Africa and documents out of Australia that covers all the whistleblower side on all of this. But it's kind of like looking at everything, taking everything into account, and then transferring it back over here. But the likes of the securitization, I did find out some points that I've not seen picked up from anyone else. So I'm just going to run through how it actually works, and then I'm going to go through this paperwork I have here that backs up everything I'm saying.
Shell, before you start, can I just quickly ask you, what were the questions that you put forward to your mortgage company that got you started? Yeah. Do you by any chance have the questions that got you started?
I do, yeah. So this is what you're looking for. When I found out about all of this, I started asking questions, especially during lockdown. The first questions you need to be asking are for proof of claim. So you're looking for some sort of letter of authority or under a power of attorney between the bank and their agent solicitor. So this would be from a knowledgeable man or woman within the bank who's taken full accountability to state that the bank is a creditor who has endured a financial loss and who is a holder in due course. The holder in due course necessitates that they hold the original note, which is the promissory note or as part of the application as part of the loan file, and also the standard security, which it's called in Scotland, or the deed or the mortgage. Okay, so those two things have to be together in their possession in order to be qualified as a holder in due course.
So what needs to be together? Okay. The deed of assignment?
It's the note and mortgage. So we'll have the note. If you look at any bond issue through securitization, it's shortened to note, and it's the promissory note, which contains the promise to pay, which is actually contained in the mortgage application as part of the loan file. So I need to explain more on the securitization side to explain that point.
Okay.
But you've got that bit, which is the beneficial interest in the payments that are allegedly due, and then you've got the standard security, which is a legal title. Now, if those two things have to be owned by the same company, same bank, in order to be a holder in due course, they cannot be split, because when they're split, neither is enforceable. So one is the security over the other. If they've been split, then it means that they've sold the beneficial title while also retaining the legal title for repossession. Okay, so the beneficial title is the right to payments, and the legal title is the right to repossession if those payments are not met. So it's kind of like, if you think about it, it's kind of like if you sell a car in its entirety and you get fully paid for it, then at the same time you can't hold the right to sell it again or repossess it back. Yeah?
Yeah.
So it's splitting of the title. So the first thing you need to do is, under proof of claim or debt validation, you're going to need evidence of all of that from the bank who are calling themselves a creditor. Right?
Right.
A
so
creditor,
the bank
as in they're a lender.
Right, yeah. So the bank calls themselves a creditor, but at the same time they make you believe that you're a lender.
Yeah. So they're a creditor lender, should be. In order to have title as holder in due course, they've also got to be able to evidence that they have suffered or endured a financial loss due to non-payment of payments that are allegedly due. Now, the proof of that should be through the ownership and the authority to have an unpaid loan account receivable. Right? So in olden times, like as I've learned, probably before maybe late 90s or so, the bank would have produced an actual ledger of a loan account receivable that they owned and they had authority to produce by a man or woman within the bank that had first-hand knowledge of that, and they would provide that as best evidence that they owned that loan account receivable and they were entitled to repayments. Okay. Now, since securitization took off, more in the late 90s, early 2000s, that loan account doesn't exist and no party anywhere holds that account, which is why they'll always produce a mortgage statement as a substitute.
So I've just got someone's just said this is also similar to sending statutory notice of equitable title, which they can not satisfy. So this is similar to that. So the bank does not have a ledger loan account receivable. They cannot produce one.
They can't and won't produce it. And I've had another bank as well that I'm dealing with, when I asked them to produce that as evidence, they turned around and said, we are not obliged to prove that there's any payments due from the borrower, but that the mortgage statement proves that. Now, what happens is that they'll always produce the mortgage statement in place of that loan account receivable, which no one holds anymore. And I'll come back to that. I might be bouncing around a bit here, but I'll need to go through all of these points here. So that loan account doesn't exist. No one holds it because they don't want it and they don't need it due to securitization. And I'll come back to that.
Yep.
So what also happens is that the mortgage statement is just a report. It's a report of something which it memorializes that something has happened, but it doesn't actually prove that something's happened. So any paperwork that you get from the bank are all presumptive documents because you have the paper trail and you have a money trail. And much of the time they'll produce paperwork, but without the corroborative evidence of the money trail to back it up. And the canton won't produce it. So this mortgage statement, and I'll come back to this again, I'll need to go back to the whole securitization process to come back to this again. Yep. So is there any more questions at that point?
No,
I'll have to come back to this.
I've got no questions, just make sure that everyone can hear and everyone understands properly. Okay, so take us through what's happened to you and right. The securitization.
So I'll go through all of these points. Like I say, I'm going to be bouncing back and forth a bit here because it is really, really complex. In the securitization process, right? If securitization is the whole point of this, because what we've got is an alleged loan that is fully misrepresented as a loan. So when we go along, our intent is to get a loan to buy a house or for anything else. We'll stick with mortgages here. So our intent is to get a loan to buy a house. So when we go along, what we're signing as part of the application contains a promise to pay. Yep. Now, when we sign that and hand it over, I'm going to stick with the legal side of this as well. I'm not going to go into the other side of this. I'm going to stick strictly with what I've been dealing with here. So when we hand it over, the alleged loan is actually a payment for the issuance of documents in an undisclosed securitization scheme. So if you think about the misrepresented loan part, it's a little iceberg above water. And then what's going on behind the scenes is the undisclosed securitization scheme.
Right.
So you hand that over, and another point I'm going to get here that I've never seen raised by anyone here before, and I've got this out of the US. The securitization happens forward. So by that I mean, if you imagine a pyramid, okay, imagine a pyramid, you've got the bottom part, you've got the top part. Right, so on the left-hand side of the pyramid is where the securitization stuff happens. So what happens is you sign the documents, you hand them over.
Yep.
Prior to that happening, up top of the pyramid with the securities brokers or investment banks, they're not entering into the lender marketplace because they don't want or need that, because it would get in the way of the selling and trading of security instruments. So what they're doing here is they're issuing a bond issue to investors.
Yeah.
But those investors, this happens first, okay, up at the top. This is what I found out, and I haven't seen anyone else picking up on this, or I haven't seen it anyway. They're selling this bond issue to investors up front. Now, at this point, there's no loans attached to it. The investors are not buying loans because there's no loans to sell. What they're buying is a speculative interest in the cash flows derived from the data points on the applications made by us at the bottom of the pyramid. Okay, so up top, they're selling speculative interests in these so-called loans called mortgage-backed securities, but they're not backed by anything. That there is no mortgages. It's a speculative interest in the cash flow. That's it. They get sold first out of a pool at the top.
Yeah.
and then they fulfill the orders from the bottom of the pyramid from homeowners up to the top. So there's no investors that are buying any loans. No loans are sold. Okay. That's one of the things I found out, and that was one of the big light bulb moments for me, because then I started piecing everything else together after that. So typically, in one example, there was a 35, I won't name the bank, but there was a £35 billion bond issue made up of thousands of these mortgages at this point. But again, it's just the cash flow, the speculative interest in cash flow. And as anyone knows, when you're entering into any investment, the value of your investment can go up as well as down. So it's entirely speculative at that point. Okay. Any questions there?
Does this make sense to you guys? So basically, there is no loan being sold.
There's no loan. There's never a loan sold. That's just all rubbish.
It doesn't exist.
And again, there's so much. I totally trust this information that I've got here with what I've researched. But again, I'm going to go through this whole thing and then go through this judgment and then pick out bits of it. I'll get to that. But like I say, I want to cover this bit first, just so people can see where I'm coming from, because I need to explain this bit. Okay, so they're selling them to investors. Now, typically, the investors are paying up to 6 times the alleged loan amount. But then you multiply that by thousands of mortgages. And in this instance, a $35 billion bond issue split up over multiple investors, and the underwriters for this, which back in 2007-8, it was AIG who were bailed out at that point. Those investments are covered by the underwriter for probably about 12 to 30 times the alleged loan amount. Now, you've got thousands of these loans, alleged loans, all bundled together in tranches. Okay? Now, it's a speculative interest, and what they'll do, they have a vested interest in ensuring that those loans do not work, that they're going to fail, because then they're going to cash in on the credit default swaps. Now, if anybody's seen the film The Big Short, it goes into a lot on the credit default swaps on that. So they're benefiting at the top of the pyramid is the investment banks who did not enter the lender marketplace because they don't want and need any homeowner obligation attached to those, because they can't trade and sell them on the SEC while they're attached to a homeowner obligation. That's why there's no loans sold.
So are you saying that, right, so let me understand this and put it as simple, because it's, I've had one lady's struggling to understand this. So are you saying that we take out a mortgage, but they don't attach the mortgage to the loan, so to the securitization, and they sell these securitizations without anything backed to it, because they can't be liable if they attach our details, our name, and our mortgage to the securitizations that they're selling, then we would be. They can't do that. They're doing it without. They're selling something that doesn't exist.
They're selling speculative interests in the cash flows generated from homeowners that are not attached to any loans. But I'll come back to the next bit here. So that happens first up top. So it's sold forward. That's one of the major things I found out probably about a year ago. That they're sold forward. So they're selling speculative interest. The loans haven't generated yet. So then what they do is they come back down to the bottom of the pyramid with us, and they're purchasing the data points and the information related to the alleged loan, which was required to be retired, extinguished, wiped out upon conversion. So basically what they want from us is for you to sign the mortgage agreement, and then to issue the standard security or the deed or the mortgage, which is the security over the payments. and the right to repossess over the payments if you stop making payment. When they've got that, it's like, right, yeah, it's like if you think of the little iceberg at the bottom,
Yeah.
what they're doing is, we need the paperwork, we've got the paperwork, we're finished, that's you done. As far as we're concerned, we got a loan, we applied for the loan, that was our intent.
Yeah.
Meanwhile, the iceberg underwater, the big securitization scheme, their intent was to get these documents issued, and they're done with us now. As far as we're concerned, we applied for a loan, we got a loan, we believe we got a loan because it was all trickery and deceit.
Yeah.
All they needed was the paperwork to be signed, so that's our part finished. So coming back to that again, what happens behind the scenes is that they fulfill the orders from a bottom up. So now they've got all of this data points, they've got all the information related to the cash flow that's going to be generated from these loans that don't exist. So in order for it to happen up top, for the sale and trading of securities on the SEC that are backed by credit default swaps, 12 to 30 times at least the amount of each alleged loan, right? So that goes up top. They're required to wipe out any mortgage. So at the bottom of the pyramid again, think bottom left-hand corner, if you like, bottom left-hand side.
Yeah.
When the documents are put over, they then undergo an unlawful conversion. So they're then inserted into a pool. Now there's a pool at the bottom and there's a pool at the top, right? So they go into a pool. When they enter that pool under an SPV, they'll lose mortgage status because they don't want or need lender liability from the top down because they're fulfilling those. They'll sell them up top, but not attached to any loan, and then they go to the bottom and then they fulfill the orders coming up. So it's a giant Ponzi scheme.
Right.
So the cash flows generated from homeowners and also from investors, credit default swaps, and different types of insurance. For example, the mortgage indemnity insurance, that promise to pay by us through a conversion into a security extinguishes all right, title and interest in any debt, note or mortgage. So that is the standard security deed or mortgage is wiped out, the promise to pay by us is wiped out, the whole thing is extinguished and it's no longer a mortgage, it loses mortgage status. So liken that to, if you were to go and scramble eggs, think of the pool as the pan, right?
Right.
So if you go and scramble eggs in the pool or the pan, you can't go and unscramble them and stick them back in the shell because they're forever changed. Same as if you've got a pot of soup and you liquidize it, you can't extract a whole carrot because it's forever changed and it's not the same instrument anymore. So through conversion, we've started off as the original creditor or investor in an unspecified, undisclosed securitization scheme.
Or scam.
So that's what's happening at the bottom left. So that's what's happening in the bottom left of this pyramid. Okay. So there is no loan. They don't want or need a loan account, so that's extinguished, which is why if you go and ask for it under bank or books of evidence or proof of a loan account receivable, they'll never ever be able to produce it. And that is why they'll substitute the mortgage statement in place of that. Now, coming to that, the bank, the high street bank, isn't a creditor because it didn't lend you anything. That payment that you thought was a loan is a record of your credit to the bank on the promissory note, which appears in your bank as, same as if you went to the bank and you paid in £100, that appears in your account as a credit. So if you sign this note or agreement, it appears in your account as a credit, but they call it a loan, which is why I rebutted all presumptions made by any titles or any paperwork, because that paperwork is entirely presumptive. It memorializes that something happened, but if you push them, they'll never be able to produce the corroborative evidence of the money trail underlying the paper trail. So it's a work of fiction. So just because they have bits of paper saying you signed this, you signed that, it can be pretty much irrelevant unless they can prove the proof of claim on all of that points I made before about them being a holder in due course who has endured a financial loss and who holds the note and the mortgage together, because that note and mortgage is split upon securitization. And that always happens. And it's always a true sale. It can't be any other way, right? Because you can't be having the title split while you're trying to sell these things on the SEC, the stock exchange, while it's tied to a homeowner obligation. Now, this is what I found out through a lot of the stuff out of the US. It's like I say, I found out about all of this here, and I've tested it.
Yep.
And I've been asking for things that I know I'm not going to get because they can't and won't provide it.
So they
so
can't.
Coming back to this, I'm almost here with this bit.
Yeah. So they're not. The bank don't loan you anything. They're a creditor, and there is no underlying loan account, which is a proof that money was lent to you in the first place. And they are wanting us to get into debt because they are purposely trying to get us into debt because of their credit default swaps. Is that right?
Yes.
Right.
So the 2007-8 crash was blamed on homeowners for taking out loans that they couldn't afford. But the reality was they were pushing loans on anybody that would take them because they were going to be cashing in on the credit default swaps up top. The bank, the High Street Bank,
yep.
And I pushed them on this as well. And I'm going to be bouncing back and forth, but I'll try and make it as clear as I can.
Simple.
The transaction, there's a series of transaction documents, right? Now, when I asked the bank for these, I was told that they didn't exist or they were confidential.
Yep.
So I found them hidden within their own website.
Oh.
And I called them out on it. Now, within these documents, I put in 3 now. There was about 9 or 10 I found. And I was always thinking that a securitization document would be one document, but it's actually made up of multiple documents. And in these documents, I put in the servicing agreement, the seller agreement, and the bank management agreement. And the bank has these, and in the servicing agreement, it clearly says they're a servicer, a seller, and a bank account manager.
Yep.
And in these documents, if you look through them, and they've all got to be read in conjunction with one another, they can't be read as one document. You've got to look at all of them. And I did pick out pertinent points in them. But what I'm going to say here is that they can be quite hard to find. They denied that they existed. And when I asked to speak to someone in their securitization department, I was told that they didn't have such a department. But yet in those documents, that department was in Milton Keynes with a full address. So they lied about that.
So they're contradicting themselves in their own...
Yeah, they've lied about everything all the way through. But I kind of knew what to ask for and get admissions from them that turned out to be total lies, which is perjury.
Right. So,
going with that as well, in these transaction documents, the bank and the servicing agreement receive a 0.12% per annum servicing fee. Now, another document I came across, again out of the US, was that the securities brokers or investment banks at the top of the pyramid, again, I'll keep going back to pyramid just so it's easier to imagine it for people. At the top of the pyramid, the data that they give to the bank, they're a designated nominee acting as a servicer for the investment bank at the top. So the investment bank are the ones that are producing documents under a DSAR. Okay, it's not coming from the bank, it's coming from the securitization scheme up top, but they use their letterheads, so it looks like it's coming from them. Meanwhile, the servicer and in the bank management agreement, cash management agreement, they're collecting payments and dispersing payments through a lockbox system up to the investment bank, and those funds are usually held offshore.
There's a
right?
surprise. So what you're saying is that they are using letterheads that don't belong to them, pretending to be court letterheads when they're not.
The banks are using their letterheads, but they're acting, they're misrepresenting themselves as a creditor. And the act here that they're moving under to claim repossession is under the Conveyancing and Feudal Reform Scotland Act 1970 that gives them rights as a creditor, but they're not a creditor. They don't have any repossession rights to either repossess or for any repayments as a creditor, because they're not a creditor, they're a servicer. It's a designated nominee for an unknown principal. So they're bringing the claim against us as the High Street Bank, going under the acts that they're going under as a creditor, when in their own transaction documents it clearly states they're a servicer. Now, the bank in my case have admitted that those documents are the proper documents, so they've admitted that they're a servicer. I got a letter from them back in 2022, and I've never ever been able to speak to the person that wrote this letter because they said they're not available. But in this case, it's contradictory all the way through. And like I said, you can't split the title between a beneficial interest in it and also a legal title interest. It's two different things. And under UCC 9203, and maybe somebody can check on that, you can't, if the titles are split, then neither is enforceable. Like I said, if you sell a car in its entirety and you get paid for it, you can't retain the right to repossess it or sell it again. So when that title's split, what they've said time and time again, and what a lot of people will hear now, I'm going to skip around again here. So you're going to go back to the bottom of the pyramid and go over at the right-hand side. A lot of people are dealing with assignments and transfers, right? Often the servicer will maybe go bankrupt, or they'll lose their servicing rights, and then they'll have a need to assign it or transfer it to another party, where they'll often record the change of title on the land registry. Okay, and then it's basically like, yeah, don't pay us anymore, pay them. But then what you'll need to see with that as well is proof of the corroborating movement of the underlying obligation, which should be that loan account receivable. Now, if the securitization is going on in the bottom left and we're in the bottom right, you want to see proof that that assignment also comes with the corroborating evidence of the money trail tracking the paper trail underneath.
There's so much to go through. This is just...
It's really complex.
It is
how much consideration was paid when they did the assignment or transfer. Now, throughout this judgment here, it's a distinctly different process, and they'll often say, oh, we've assigned the beneficial title, but we retain the legal title, which is splitting of the titles, which means that neither is enforceable. Because they've got to stay together.
Right, so they have split the title, so they can't enforce anything on you.
No. So if they're splitting the beneficial from a legal title, then it means that they're trying to repossess something that they've already sold or assigned. But you need to see the corroborating money trail backing that up in an unbroken chain of title. But they tend to rely purely on the paper trail rather than the money trail underlying it as well. So you need both. You need to see proof of full consideration. So getting back to this point here again, it's in my case, I've asked for proof of claim, the letter of authority, power of attorney, stating that the holder in due course who have endured a financial loss due to non-payment and all the rest of it. Now in this judgment, the judge has come back and said that she's confused the points, and I find it highly, it's either a form of gaslighting or
so are we
it's
going,
a totally confused point. Because I've asked for that.
Cheryl, can we going? Can I just say, are we going through your judgment now?
I'm going to be bouncing back and forth.
So because
with all of this, because I need to.
Yeah. So just to let everyone know that Shell has been to court, and this was last month, And
May.
so,
May.
yeah, oh, was it
Aye.
May? Oh, okay.
A
Oh,
few
yes,
months ago.
sorry. A few months ago, yes. And
Oh,
things happened when she was in court, a series of events. Are you able to speak about what happened to you in court?
yeah.
Right, yeah.
Okay. Yeah. So I'm going to go to that. Right. The first time I've been heard in here, railroaded through an admin court, which is not a court of record. I think we're all railroaded into that with this.
Yeah.
So what I'm going to say here is I had an argument with the judge for the first few minutes and she left the court. Now, what happened here was she says this is a straightforward repossession and they'll always say that. And I said, no, it's not. It's subject to securitization, which means that the mortgage has been extinguished. It's no longer a mortgage. And all the points of securitization, which I'd already put in my defence. I went into great detail on all of this, and I also put in 33 exhibits with all of this. And I'd said to her, well, we had an argument. It was quite an argument. It got quite heated. Okay. So what happened in this case was I was arguing my point, and she was trying to deny it. And I said to her, have you looked at the documents I put in? And she said, I looked at them last night. And I said, well, what bit of it did you not understand? So eventually what happened was she left the court, she came back in, and I was able to speak for an hour and a half, and I laid out everything in court. Now, I recorded this on my phone, right?
Yeah.
There were signs up to say you couldn't, but I stated I made that recording for my own protection, given the level of disclosure I was making. Now, before this hearing was adjourned at 12 o'clock, I stated which party would benefit from the proceeds of a repossession because it's not the bank, because they're not a creditor. And then 5 minutes later, she adjourned it from 12 until 2. So here's the next bit. The next bit, my phone was seized, and I was told it was going to go to the Procurator Fiscal. So it's a Crown Office Procurator Fiscal Services for an investigation into holding me in contempt of court.
Because you recorded.
So, because I recorded for my own protection, given the level of disclosure I was making, because I knew I was going to be putting all of this on the court. Because of the amount of questions I've been asking, there was absolutely no evidence from their side on everything. I'd had repeated lies made. They refused to supply any of the documents that I had. And the court at this point had not one single scrap or crumb of evidence on the other side. Nothing. Nothing to prove their claim. Nothing to prove they were a holder in due course. They couldn't answer it. Nothing was answered. So I did that deliberately.
Yeah.
So the next thing, the phone was supposed to go to the Procurator Fiscal. And I said to them 2 days after that hearing, the other side came in with documents. And I don't know if I can say this here, but I'd already made it clear they were trying to kind of tar me with the same brush on arguments that other people had been making for quite some time. And I stated that my whole claim was based on they need to prove their claim. They need to prove that they're a holder in due course and that they have a right to repossess or demand repayments when they'd already admitted to securitization. And in the letter of 2022, and this comes down to the point of separation of title again, they stated here that the legal title to your mortgage has always been owned by the bank and has never been sold. Well, at the same time, they're admitting to securitization, which is always a true sale. Otherwise, they wouldn't be able to trade on the stock market. They wouldn't be able to sell or trade on the stock market. Like, as I said, they're sold forward and then fulfilled from the bottom up. So
they're really contradicting each other.
They've admitted there that they've sold it, but they retain the legal title, which is a split of the title, and therefore neither bit is enforceable. So they've admitted that there. They've also said that your mortgage was securitized for a while, but now it's not. And it's like, well, once it's securitized, like the scrambled eggs, you can't stick them back in the shell. You can't securitize it.
So when
securitize it.
Shell. So when something's securitized, it goes into a big pool. You can't then take it back out because it all gets scrambled.
You can't. Once it's been securitized into a pool, it loses mortgage status because it requires for all right, title and interest and any debt, note or mortgage to be extinguished because they wouldn't be able to trade and sell it on the stock market while it's attached to a homeowner obligation. So once it hits a pool, it loses mortgage status, and that is what I've gone into with the US side of things from a 50-year trial lawyer and investment banker. He states that in over 180 hours worth of podcast content. So there's that. They also say that...
Can I just pause you there 1 minute? Someone's just asked, what judgment are you citing? This is her judgment from court. Does every single mortgage get securitized?
What I've learned is yes, 100%. Yeah, so there would be no loans without the securitization side. And again, they'll never ever tell you that it's been securitized, but they might tell you that it's been assigned or transferred or whatever. That's a different process. And again, this is what I found out with a lot of the research I've done, and it kind of matches up with what I'm saying here, because I did have a few light bulb moments, especially when I learned that they were sold forward. So it happens up top before it happens at the bottom. The things are sold to investors up top, and then the orders are fulfilled from the bottom up. But it's only a speculative interest in the cash flow because we believe that we got a loan because that was the intent. The actual intent of the servicers, which is the high street bank, misrepresenting themselves as a creditor because they didn't loan anything.
Yeah.
Then they're acting as a servicer receiving a servicing fee. So I'm going to go through this judgment. So the first point I'm going to bring up is me asking for proof of claim with their authority, their status as a holder in due course and all the rest of it. And the judge, sheriff, whatever, came back and said that their solicitor on the other side for the bank has no duty to prove their credentials in court. Now, as a judge, that's total gaslighting on my side, because that's not what I was asking. And she should have known that as the judge, because surely she can't mistake me asking for proof of claim and their status as a holder in due course is being me confusing that point with them stating their credentials in court, the solicitor's qualifications. It's a total, it's like total confusion and missing the point entirely. So and it's also avoiding the point of prove your claim.
Right. So you was asking about the mortgage. Yeah, you was asking about the mortgage proof of claim, and she was trying to say to you the solicitor doesn't need to give you his credentials. So she's gaslighting.
Totally skipping the issue.
Away from the mortgage.
Skipping the issue. Totally gaslighting.
I've got here. I've got here. People. I can't share. People are asking if I can share the judgment. I can't because it's still ongoing. But if you can let me know what page you're at, so that I can follow where you are roughly.
Page 3, paragraph 2.
So
that bit.
Right. So
the next bit.
Yeah.
Right, the next bit, I'm just going to run through this, and like I say, I might have to bounce back and forth with explaining points as I'm going along, but I'm just going to run through this. Right, so here I'm going to say a point here. I'm going to state this right now so that people can look at what I'm saying and then see the relevance of all of this, right? So another point in here, what I'll say, she said, is that if I succeed, a great percentage of mortgages and loans written across the globe should be set aside.
Which is why they don't want you to succeed. So basically she's admitted that if you win this case, it will wipe out mortgages and loans.
Across the globe?
Well, yeah,
So that's an admission from her that there is points in this that have merit. Now, she's also said that there are points in everything I brought up that have merit, but she's not specified what points have merit. So I'd be quite interested to find that out, because I can take this from anywhere she wants, and I can take it from anywhere and go into stuff in question, but I've not been able to speak to anybody within the bank on any of the points I've made because they don't want to talk about it. That's quite obvious. Going back to the phone issue, and I would like some insight on this from anybody. Right, that phone was seized under contempt of court for recording in court. Now, 2 days after that hearing, the other side put in something to say that I'm following the same argument as, and I'm going to say this as well, okay, so it's the Ian Stamp, Ian Clifford Matrix Freedom stuff, right?
Oh.
Now, she's trying to kind of say that I'm following the same thing as all of that, and I says, no, I'm not. My point here is prove your claim. So with that as well, I had kind of rebutted all of that.
Yeah.
The phone was seized by the police and I was under threat of arrest during that 2-hour adjournment if I didn't hand over my phone. So a complaint was made to the police on that. So I reported the sergeant who seized my phone to her boss and also his boss. A report was sent in from that to the Police Standards Department, and the phone was supposed to go to the Procurator Fiscal. Now, when I got that email from the solicitor 2 days later saying, oh, look, she's running under the same thing as all the Stamp Clifford stuff, right?
Do you think Ian has been, do you think Ian, where Ian Stamp has ruined and lied and scammed so many people when it comes to doing this mortgage claim back your money? So they're trying to tie you in and make you look ridiculous like him?
Yeah, because there's some points here where, oh, hold on, give me a second till I find this bit. Right, okay, coming to a point in this, she says, right, the judge who oversaw the whole Clifford stuff had described it as a get-rich-quick scheme, right? And then she also went on to say that I outdistanced that as an opportunist in this with what I was claiming, right? She also said that there was no case of unjust enrichment. Now, what bit I've come across with this as well is if no payments were due to a true sale securitization, then that is unjust enrichment because it's been wiped out through securitization, where the investment bank are insuring these things to investors under credit default swaps for, like what I've learned is 12 to 30 times the original loan amount multiplied into thousands that are sold on bond issues. And one I came across was for £35 billion split over multiple investors. So that was that bit. So the unjust enrichment comes from, and if you look at it from another point as well, the mortgage indemnity insurance kicks in after 90 days of non-payment.
Yep.
So if they claim under the mortgage indemnity insurance, and I've raised this point as well, I asked them who benefits from the mortgage indemnity insurance, and I want to know when it was paid out and how much was paid out, seeing as this alleged loan has been in dispute or in default for so long. My point I made to them was the bank is a servicer and not a creditor. If they're not a creditor, there was no loan, there is no default. And therefore it's unjust enrichment for them if they're claiming on the mortgage indemnity insurance. If they're not benefiting from that, then who is? And if they're not benefiting from it as a servicer who is not entitled to it, then another party is. And therefore you've got more unjust enrichment because it's double dipping, where they're claiming on the insurance, not only through the indemnity insurance at one point, but also through the credit default swaps at another. And bringing all this into an engineered default in order to benefit from the credit default swaps up top, the engineer a default, You had the 2007, 2008 default, and then you had the 2020 pandemic, which was part of an engineered default to make them benefit from a credit default swaps up top.
Can you just quickly explain how credit default swaps work? You probably have already, but I'm trying to get my brain around this, and I think a lot of other people are as well.
Okay.
So
we'll try.
Yeah.
How does credit default?
What is a credit default swap?
Right, the underwriters attached to the the security brokers at the top, they insure everything under credit default swap. So it's a form of insurance. Now, if you've got a car worth 5,000 and you go and insure it for 30,000, then that's fraud.
Right.
So they've got a vested interest in ensuring that none of these loans work, because that way they don't have to keep paying the investors on their speculative investment in the cash flow derived from the data points from homeowners for loans that don't exist any longer due to the conversion of those documents into securities, where the actual mortgage is extinguished at the bottom of the pyramid, if you like.
Okay, so is it a bit like? Is it a bit like if you've got a car, you've insured it for you know, £2,000-3,000 above the asking price, and then you decide to burn your car but claim the insurance money? Is that the sort of thing they're doing, that they're wiping out our mortgages but still claiming the full insurance on the mortgage back?
Under the credit default swaps at the top, because the high street bank, all their role is, if you like, is to generate paperwork from us for the purposes of an undisclosed securitization scheme. So we're actually creditors and investors in a scheme that we're told nothing about. We didn't give our consent to have our data traded on the open market in, you know, the securitization scheme up top for the benefit of the securities brokers. And there's another angle to this as well. The investors coming in, right, that are purchasing these so-called mortgage-backed securities that are not actually backed by anything but a speculative investment that can gain or not, they only pay them for as long as they want to. They can insure their investments and then they get paid out from that. So no party anywhere within a securitization scheme, which is what's happening behind the scenes, no party has any skin in the game, no party is at a risk of loss, no party has any loan account receivable on their books that is going to be paid down by the proceeds of a repossession or for any repayments made by homeowners. So if you like, that income stream from us at the bottom goes straight through a lockbox system to the investment banks or security brokers at the top of the pyramid, and no one is at risk of financial loss anywhere within this entire scheme. So for a contract to work, if you get an alleged loan, then you would expect to have a counterparty risk on the other side. So they're at risk of loss if you don't pay.
But that's not
right.
The case.
There is no counterparty risk anywhere, because that risk was extinguished upon the conversion of your documents into the securitization scheme. So there's no risk of loss, there's no counterparty risk. None of the proceeds of repossession go towards paying down any loan account, because it was extinguished, because for the purposes of trading on the SEC at the top, they don't want or need loan status or lender status, because then there's a tax thing attached to that as well. So if they call it a loan, you can call yourself Mickey Mouse, but it doesn't make you Mickey Mouse. They can call us a borrower, but it doesn't make us a borrower without an actual creditor or lender, which is not the high street bank, because in their own transaction documents, it clearly states that they're a servicer receiving a servicing fee. So they are not benefiting from any of the profits of a securitization, because those profits go up top, usually offshore. And the other side of that as well, I put in 3 documents that were related to I put in an FCA report for this bank when they were fined for money laundering. Now, a lot of the time, and I put in another document that goes into this in a lot of detail as well, often those investors, they're using that as a conduit to launder money through the banking system in so-called legitimate mortgage-backed securities. They don't care about a return on their investment. All they care about is laundering money, which goes straight back to them, posing as investors, but they're not really. They're laundering money through the banking system under a seemingly legitimate process of purchasing into investments in mortgage-backed securities. So there's that aspect as well. So the banks are facilitating that. So they've got an income stream coming in from that. They've got an income stream coming in from homeowners up that is not attached to any loan because that loan was extinguished at the bottom. And then you've got the title being split because when they securitize it, it has to be in a true sale, but then they retain the title on the land registry to come after us for rights to repossess. Well, in the background, this has all happened and it can only ever be under a true sale because it couldn't be traded otherwise. In another point in here, just see if I can find it. Hold on.
This is shocking. Absolutely shocking.
Yeah. Right, so there's another point to find out as well, and this comes down to AI. And I've got a document on this that I put in as well, out of the US.
Yeah.
These reports, you've got the mortgage statement, right? Now that report is just a report. It must have had to have been made off of some sort of ledger from somewhere. So you can't just make up a report without the actual bank ledger. So if somebody loans you £1,000, you'll want to see proof of their bank account where it's come out and then your bank account where it's gone in. You won't rely on a bit of paper that says this came in, this. You want to see the actual ledger, right? So these documents, these reports are issued through AI from the investment banks or the securities brokers within the securitization scheme, but they're using the high street banks' letterheads to look like it came from there. So in my case, I got an internal stream listing. Now I know a lot of people have had this, right? So it's an internal stream listing, and on that, and I know a lot of people might have come across this as well, under a securitization code, you've got figures coming in as a credit, and then you've got them being reinstated and going out again. And in my case, there's 8 double transactions. So the money comes in as a credit, it takes the balance down to 0, and then it's been reinstated again. Now, that was obtained under a data subject access request, which presumably came from the bank, but they deny all knowledge of that. And then in another document, the customer statement, none of those transactions show up in that customer statement, which they're relying on as a substitute for the loan account receivable, which was extinguished through securitization. It doesn't exist on anyone's books. So they're relying on the mortgage statement. So one thing, they're acting as a servicer.
Yeah.
So you would expect to see payments coming in and then being dispersed to a third party as a servicer. But because they're misrepresenting themselves as a creditor, you're not going to see that. So that report is incomplete and hearsay. There's also nobody from the bank that is going to step forward, a man or woman, taking accountability, who has first-hand knowledge of that report, because it wasn't made from the high street bank. It came from within the securitization scheme up top, looking like it came from the bank. Yeah. Which is why they're saying that they don't know where these transactions come from. And the total over £600,000 on a £72,000 mortgage.
That's right. That was your, yes.
So I've asked them.
That's how much went through your bank. So there was a, yeah.
8 double transactions. So I've asked him, where did those funds originate from? Now, another document I put in, again from Neil Garfield, it was a witness statement on all of this, where he clearly states that the only 2 parties in interest with legal standing is the investors, because they've been conned. They've got nothing to do with this scheme. They're investors coming in that have purchased the interests in mortgage. They're told they're mortgage-backed securities, but there's no mortgages attached to them because it was extinguished. Also, they would have legal standing, and we would have legal standing.
Yeah.
As undisclosed creditors or investors in an undisclosed securitization scheme. He states that the bank has no legal standing at all. Zero. Right. And that we would be due rescission in all of those repayments that were made that were not due to lack of consideration, as in there was no loan made. There's no counterparty risk because that was extinguished upon securitization. So there's nobody with any risk of loss anywhere except us.
Yep, we're the ones that lose, and they're the ones that...
The whole pandemic was done as part of an engineered default. You know, you'll own nothing and you'll be happy.
Yep.
It's part of an engineered default asset grab so that they can cash in on the credit default swaps at the top of the pyramid.
So it's a bit like the wars that they orchestrate, so they can land grab and they can, you know... Yeah. So they are also orchestrating... defaults, purposely making you go into default by depriving you, making you lose jobs, putting you in hardship, so that they can do these credit default swaps and gain and cash in on the massive insurance that they've put on it. Is that right?
Yeah.
Right.
Yeah.
Oh, are you there? Yeah.
Throughout this judgment, just collecting some pertinent points.
It's actually quite shocking.
Right, so throughout this judgment, she's admitted time and time again that she's not clear on this point, she's not clear on that point, she doesn't quite understand this, and it's apparent to me that she's confused an assignment or a transfer with a securitization all the way through. She's also stated that if it was a true sale assignment, then it would be declared null and void from the start ab initio, and the whole thing should be struck out. Now, like I've said, they've admitted to me that there was no assignment or transfer, and what I'll say from what I found out as well is all these assignments and transfers, it's paper transfers. If you ask for the corroborating money trail underlying it, you're probably not going to get it. But under a securitization, like I'm saying, I know there's a few, it's always a true sale, is what I've learned, because it can't be traded otherwise, whatever they tell us, right, that. So, comes back to, there's another bit here. Okay, done, just see things better, so much in here.
So they create a wall within the banking system.
I'm gonna say some points here on this title split thing that are quite contradictory. So if people can kind of look at this. So the point on, I put in the mortgage sale agreement, the servicing agreement, and the cash management agreement. And what they've said here, hold on. That I claim that the bank have committed a fraud in the land registry as title in the standard security remains with Santander, not having been transferred to any third party. It is not clear to the court how both arguments can be presented at the same time. So they're basically trying to say that they don't understand how Santander, the bank, retains legal title and at the same time have securitized it. She doesn't understand how those two arguments can be brought forward at the same time. And the argument with that is, if you've securitized it and you've admitted to securitization, which is a true sale, you can't be retaining legal title on the land registry. But they're trying to say, well, because they have got the title on the land registry, then it gives them a right to sue. And It's like, well, not when you've admitted to selling the beneficial interest, but actually it's a true sale. And she's already stated that if it was a true sale assignment, that it would be void from the start.
So basically,
and it can only ever be a true sale securitization.
Yeah.
So she's basically admitted calling it an assignment, but like I say, she's confused assignment and transfers all the way through, where I've clearly stated, and I've got proof from the bank stating that it was never transferred or assigned, but it was securitized. So she's confused that right through the whole thing, and she's clearly been told that it was never assigned or transferred, but it was securitized, and here's the proof. And here's the internal listings document with over £600,000 going through this account, where it's been settled 8 times. Now, it doesn't matter, like I'll use this analogy here as well. If you go into a restaurant, you're sitting having a meal, somebody comes in unknown to you and pays your bill, the restaurant has a choice to either come to you and say, yes, your bill's been settled, and it's like, oh, well, thanks, fine. Or they can come back to you and say nothing and charge you again, which would be morally wrong, it would be fraudulent, and it would be double dipping or unjust enrichment for them. So that's what's happening here. So they've sold it, sold all right title and interest in it to any debt, note or mortgage, and yet they're still claiming repayments in unjust enrichment for something that's already been settled and should have been discharged in a land registry. And there's a report out of South Africa, because they're way ahead on this, much more than us, I think. There was a study done on 600 mortgages that were all subject to securitization, and not one single mortgage was recorded as settled or a new owner on the land registry. So what we're going after is to ask, who owns the alleged loan, who is the holder in due course, who's endured a financial loss, and they need to prove their legal claim against us. And in this case, in my case, they've got not one single scrap of any of that. And also, they've never even raised the point at all. And that point she'd made to me about if it succeeds, a great percentage of mortgages and loans written across the globe should be set aside. And prior to that little bit, I'm just going to go through this as well. She says here, indeed, it is not only mortgage loans, but in fact, every sort of financial transaction in the economy that is subject to securitization, which is true. Student loans, car loans, lease agreements, credit card agreements, aircraft leases, milk quotas, everything could be securitized.
And do they follow the same procedures?
Right? Everything. So basically, there's a heavy court bias against the homeowners and for the banks, which is a conflict of interest, because if this was to happen, if anybody was to get through, then typically, well, that could be an issue. But then the other side of the coin, again out of the US, that I found is typically these cases are won on insufficient evidence. Now, if they've got no evidence of their proof of claim, that should be insufficient evidence. And also what I've learned is typically when these cases are won, and they are won,
yep.
And this is coming out of the US as well from same Neil Garfield, he states, the court record is always struck.
There's no record.
There's no court, the court record is struck.
And they have to
in
sign.
all of these cases. So there is no record of any wins. And that is why in here as well, she stated somewhere, and I can't find it right away, that she said there's no incidences anywhere within the UK of any homeowner winning.
They won't.
Right? And he states that it's usually a payment is made under a non-disclosure agreement, basically to shut up. So, or there's a claim in rescission where all the payments are made back in rescission because of lack of consideration, of lack of counterparty risk, and because none of those payments were due to true sale securitization, or else in reformation, where you've got the misrepresented loan and the undisclosed securitization scheme is all taken as one contract in reformation, and all of the hedged derivatives, like say your mortgage indemnity and your credit default swaps, are all taken into account, and then a settlement is made based on that.
So you're saying,
reformation.
So you're saying that non-disclosure mortgage arrangements do happen. because there are people that don't believe that there are, you know, people out there that have managed to reclaim all their mortgage and more, but they've done it through a non-disclosure, which means it's not on a court record. It's like it's what Ian Stamp has been selling to everybody, but the problem is
scrubbed. It's scrubbed.
Yeah.
And that's coming from Garfield.
So are people winning that? Very, very few.
What I'm finding, what I've been seeing here is, and I think that's what's happening with a lot of people, is that they're raising the same issues, and what they're trying to say here is, oh, these issues have been raised before and all the rest of it, but they're not relying on proof of claim on the other side. It's not even been raised with me. They've never even entered into it, because I've asked for proof of claim, and that's what my whole defence is based on. Show me proof of claim. Show me that you're a holder in due course, that have endured a financial loss. And also what I asked in court was which party would benefit from the proceeds of a repossession, because it's not them, because they're not a creditor. The transaction documents that they told me didn't exist, I managed to pull, and it clearly states they're a servicer. So moving under the 1970 Act, which is open to a creditor, they're falsely moving under that in a repossession because they're not a creditor, they're a servicer. And a servicer for who?
So they're using an act.
And they're not.
They're using an act they cannot actually stand under.
They can't stand under it in the rights of a creditor, because they're not a creditor, so it's a misrepresentation. And they're not going to benefit from any of the proceeds of a repossession. They haven't made any financial loss because they're not a creditor. They're a servicer receiving a servicing fee. So none of the profits. She's trying to say that they're making profit from securitization. It's like, no, they're not, because they're not a servicer. The profits are retained up top with the securities broker, who didn't enter the lender marketplace because they didn't want or need to, because as long as they had us believing that we applied for a loan, and as long as those payments are coming up through a lockbox system to them at the top, it's a giant Ponzi scheme, because the investors are being paid from new investors coming in, the money trail going from the bottom to the top, the credit default swaps that they're cashing in on under an engineered default, being the pandemic was one, the cost of living crisis, the escalating mortgage interest rates and all the rest of it, where people are falling into default, and then they'll move in on repossession with no claim, with no proof of legal standing. The courts aren't even asking for it or even bringing it up. And then they're moving under that, not listening to what anyone's saying and dismissing the whole thing because of the heavy court bias against us on the side of the banks. And there's got to be a conflict of interest there somewhere as well. And then at the same time as she's saying that if I succeed, mortgages and loans written out across the globe, while at the same time she's telling me that my claim has no merit and that it's baseless, and that I'm trying to extort money from the bank. And
did she not say that she doesn't understand this?
Not addressing.
Did she not actually? Did she not actually admit that she doesn't actually understand this?
Yeah, constantly. There's 53 paragraphs here, and I've gone through every one, and then practically every paragraph it states, so we're not quite sure about this, we're not quite sure about that. I must confess, I don't quite understand this. Blatant, very obviously confusing an assignment with a transfer and an assignment with a securitization, and also stating that if it was a true sale assignment, then it would be knocked out, it would be set aside, it would be struck out. But like I'm saying, despite what we've been told in the official narrative, that they're only selling the beneficial title and they're retaining the legal title, well, that's fraud through the land registry, because at the end of the day, it's only a registry. It doesn't signify proof of ownership when they've sold it under a different process, which splits the title. And when you split the title, neither is enforceable, because they've got to stay together in order for the bank to have status as a holder in due course, which is a precedent before any action against us. And they're not proving that. And when you ask them to prove it, they can't. And that's why that confusion bit is where she's come back and said that the solicitor isn't obliged to prove their credentials in court. And I can't get, well, I do get, but what I'm saying is, how can a judge confuse the two issues? Because every case, everywhere, for any purpose, needs proof of claim on the other side. If they've got no proof of claim, then they can't possibly enter a negative judgment because they've got insufficient evidence, which comes back to the Garfield claim that these cases are usually won on insufficient evidence because they can't prove their legal standing as a holder in due course who suffered a financial loss. Because there is no loss anywhere within the securitization scheme, because nobody holds an unpaid loan account receivable, because it was extinguished upon conversion of the documents into security instruments, so it loses its mortgage status. What the other side tried to say that I struck down as well was that in regards to the transactions on the internal listing, he tried to say that those are paid, what was it he said? Those signify when a mortgage was taken in and out of a pool depending on when it was in arrears or not. And I'm like, no. Once it hits a pool, it loses mortgage status because that's a requirement before it can be traded on the stock exchange, because you can't be trading it and selling it while it's attached to a homeowner obligation.
Well,
because they don't want to lose lender status.
If they
That's
were,
why it's wiped out.
If they were trading it and selling your mortgage, that means that whatever profit they make should come to you.
Again, I put in a witness statement from Garfield, and I put this in as not as evidence because they've struck it out, but as information in respect of this subject matter. And in there, he clearly states that there's credit payments due to the borrower, the alleged borrower, as their share of the profits derived from securitization, because they've been drafted into an undisclosed securitization scheme while excluded from a share of any of the profits. So you've been drafted in under false pretenses, misrepresented as a loan because you believed and that was your intent, but their intent all along was to secure the paperwork that could be converted into tradable securities. And those credit payments through that are credit payments to the borrower as part of their profits derived from the securitization, selling of securities linked to their data points that were taken. So there's no loans that are sold. Investors are not buying loans, they're buying a speculative interest in cash flow, that's it. So the underwriter, I heard as well, does typically they'll learn about 15% or so. So there's a lot less money in actually providing real loans, because if it was a real loan, you would have a counterparty risk on the other side, and they would have that loan account receivable.
Yeah.
They would retain the original note, the original loan file, and the security over it, and they would be able to produce all of that as evidence. So the securitization happens like on the bottom left, well, on the right-hand side, and what I've learned as well is this whole multiple layers, multiple players involved in this, they'll say, oh, it's been assigned here or transferred here and assigned here, so it ends up being like a massive cobweb. And she stated in here as well that without a full securitization forensic audit, she's got no way of knowing any of that. So why you should pass a judgment against me with no evidence on their side, no corroborative evidence on their side, a complete confusion all the way through this thing, confusing assignments for transfers against the securitization, coming out with points. For instance, there was a point in here as well about the title split, not understanding why both arguments could be argued in court, because the bank you signed a standard security to the bank, and she's not quite getting that, yeah, as long as they don't go and register a new owner, that is fraud, because it's telling us that, yeah, we hold this, we hold that, meanwhile we've sold it, but we're not going to tell you that, because why tell you? Because then you'll see that there's something else going on here. And a lot of the documents out of South Africa are backing that up as well.
Yeah.
There's quite a lot of stuff I put in
You have done
on
amazing.
the subject matter.
You have done amazing.
And coming back to the phone issue, I had says to the court, yeah, I'm more than happy for that phone to go to the Procurator Fiscal, because it is in the public interest, and that's their remit, to go to the Procurator Fiscal, and for them to investigate the contents of that phone and everything they disclosed, and I'm more than happy to provide any further information to help him with that. And that phone never ever got to the Procurator Fiscal, but when I went down to see about it a few weeks ago, I was told that the contempt of court charge had been dropped, because I previously brought up the point, can't be held in contempt of court for a court that's not a court of record, therefore it's an admin court. So this case shouldn't even be heard in there, because they're railroading you through in that system. There's a whole other point to this as well, with the name, the all caps name and stuff, but I'm going to stick with what I'm doing with this just now, but there's that as well. I mean, they're moving against all caps name as a legal fiction, where meanwhile it's a living man or woman that's being damaged.
Yeah.
With that, but I'm not going to go into that too much, but there's that as well. So basically they're moving under the rights of a creditor while not being a creditor, falsely representing themselves as a creditor, which is also perjury, because I've asked them numerous times, what's your position? And they say they're a creditor when they're not. And they've also now admitted that the transaction documents are the correct ones, even though they told me that they didn't exist or they were confidential. So they didn't want me to see them.
Yeah.
And I held them up in one of my hearings. I held them up and shook them in front of the solicitor and says, what's this? It says, these are the documents that you said didn't exist, and yet here they are. So why, what's going on here? So they've now admitted that those are the proper documents. And in the cash management agreement, it states in there as well that they are collecting payments from homeowners as if they hadn't sold it.
When they have.
So that payments go from us to them, and they go through a lockbox system to another party. Now, I've been in touch with BACS as well, the Bank Clearing Place, BACS.
Right, yeah.
And I kind of asked them, I says, right, if they're collecting payments on behalf of another party, but they're not disclosing that, is that a problem? And I didn't delve into it too much, but they said it was.
Ooh.
Or they need to disclose who they're collecting payments for and where they're going. And all of these, at the top of the trees, well, at the top of the pyramid, if you've got a Ponzi scheme where money is coming in from the bottom up, it's coming in through fraudulent repossessions, it's coming in through investors in credit default swap payouts and stuff, you've got a massive slush fund at the top that's usually held offshore. Right. And then you've got the investors, like I said, we're often told that the banks are fined for money laundering or facilitating it. But these investors coming in often it's a conduit for money laundering through this as well. So you've got that aspect of it too. And then you've got to know where those funds are coming from and what's behind them. And then you've got a whole other issue there with that.
Did the judge?
It could be coming from trafficking, it could be money laundering, trafficking, drug trafficking, human trafficking, all sorts of things. So you've got that issues as well.
Wow.
So that's another aspect to it as well. I put in 3 documents about that, and they were all tying the money laundering thing to the securitization process. And meanwhile, in the official narrative, we're told that it helps to drive the real economy and allows the banks to further lend. Well, if we're speaking about the high street banks, they're not lenders or creditors. They're a designated nominee posing as a creditor who receives a servicing fee through the banks at the top, well, the security brokers at the top.
They literally are mafia, aren't they? Yeah, that's right, Laura. Their banks are mafia. Did the judge?
So you can understand.
Did the judge say to you? Because I've heard this on another case before when we were in court, and I think, if I remember right, reading your judgment, the judge said it doesn't matter what they're doing, you have a duty to pay, and that's all you need to worry about.
Yeah, because they're not demanding proof of claim. So everybody needs to jump on that and demand proof of claim from the banks, because they're not creditors. So the obligation was extinguished upon securitization, and no loans would happen without securitization, because that is the intent all along. It's because the too big to fail banks, usually the big US banks, too big to fail because they're facilitating the selling and trading of securities that are derived from data points and information from homeowners signing paperwork in a misrepresented loan, and then the securitization scheme is entirely undisclosed. The other side of it is the assignments and transfers, where you would see, like if that servicer was maybe lost their servicer status, or if they went bankrupt or taken over or whatever, they're going to assign the collection of payments as a servicer because they're servicing. It just means that the payments are being collected by a different party, and then they'll register that in the land registry often. But what's going on the left-hand side bottom of this is that the securitization has happened right from day one. So that mortgage loan that we thought is a loan, because that was our intent, was extinguished as soon as the thing was converted into a security, because it no longer holds mortgage status, because they're making just bucket loads of money off the back of that. Well, so, for instance, if you've got a 100,000 mortgage, alleged loan, they're making probably 1.5 to 2 million on the backside of that.
Well, you saw
so they've
600.
Got no intent of ever telling you that it's been securitized.
Because if your name was still attached to that, you would be entitled to a share of that.
Yeah, you are as an undisclosed investor, but then you're going to have to see a full forensic audit related to your transaction and what's happened with it within the securitization scheme under reformation, taking the entire misrepresented loan and the entire securitization scheme as one contract, looking at all the mortgage, the insurance payouts, the credit default swaps, and everything else into account. In reformation, that's what the Garfield stuff says as well. So I'm going to touch on this just a second, okay? And I'm going to touch on it and then disappear again. So I'm talking about securities and reformation. Yep. So I'm just going to dip into this. NESARA, GESARA, I'm just going to touch on that. The National Economic Securities and Reformation Act. So what I've just said is taking the whole securitization process into reformation and looking at the two contracts as one, and then reforming the whole thing, taking into account the insurance payouts, the indemnity insurance payouts, and all of that. So if you look at that, the first point in that NESARA, and again, I'm not going to dip in too much, but it's a whole list of points on it. But the first point is debt forgiveness due to banking and government corruption, right?
Oh, right.
Under Securities and Reformation Act. So if you're looking at reformation of the entire two contracts, it maybe touches on that, but that's as far as I'll go with that there. So it's not, that is one of the remedies that Garfield speaks about, and also rescission on all the repayments that were made because they were not due, because the entire thing was misrepresented as a loan, which is a breach of contract. It's negligence, it's breach of contract, it's you've got no consideration paid, you've got no counterparty risk, you've got no full disclosure, you've got no real meeting of the minds, and you weren't able to negotiate. Now, another point I brought up in court was, if that whole thing, she says, oh, securitization isn't illegal. And I was like, no, it's not illegal. It happens. It has happened for years. The illegal part of it is that we didn't give our consent for securitization. Now, what they're saying is, in the terms and conditions, the bank has the right to assign or transfer your mortgage, right?
Yep.
So yeah, that bit. But it doesn't mention securitization anywhere within that. And I was told by the bank that it mentions it in the certificate of title. The word securitization doesn't even enter into that. So there is no consent given to securitize it for the purposes of trading and selling the data points to investors for massive amounts of profit, while still chasing us for repayments on something that's already been settled. They've made massive amounts of profit, and that's where the unjust enrichment comes from. And she stated in this judgment again that I haven't stated where the unjust enrichment is, and I have over and over again. So that again is either not understanding it, not comprehending it, or a deliberate attempt to gaslight again, stating that, well, she doesn't explain where the unjust enrichment comes from. And I think you would have to be a total idiot, totally incompetent, or just not wanting to see it deliberately to try and argue that point when it's been brought up and explained in great detail. So there's a problem with that as well. And she also states here that, as I said, securitization is legitimate in our legal system. Yeah, but as a point I've just made, it's illegal, and out of South Africa, lots of stuff out of that as well. It is illegal to repossess a property when it's subject to securitization due to it always being a true sale securitization. Despite what they tell us, to the contrary otherwise, because to admit that, they'll never ever admit to it. And like I say, I confronted them with the internal screen listing because I knew what it was, and it was only then that they admitted it. But they tried to say that it was securitized for a while, but now it's not. And it's like, that can't happen because it loses mortgage status. It loses, the obligation is extinguished from us. It's no longer a mortgage, it loses status, and therefore they have no right to chase repayments or to chase repossession because of that.
Yeah, so I've got a comment which would help maybe. So someone is struggling because they said the conversation we're having is quite turbulent and it's been quite hard. There's a huge opportunity to talk deeply about corruption of bank, but it's been so fluctuant. If you're wanting to reach an audience and to create a movement, you need to have focused conversations. So the fact is, we can't give out the judgment. So the documents can't be put out because this is actually an ongoing case, and Shell's sharing parts of the case, so to help people understand the journey and the corruption. So this is why she's talking about the fact that all mortgages, from what she's researched, from hours and hours and actually years of study, are fraud because they get securitized. And so she's delving into the securitization and showing us how they are purposely trying to get us into default so that they can cash in lots of money on us, and something called credit default swaps. So is there anything that you could tell people to, if they want to understand even more how this works? Would you recommend the Garfield, what's his name?
Neil Garfield. If you look up the Neil Garfield show,
I think someone's put a link.
Garfield like the cat.
Yeah.
If you look up the Neil Garfield show, it's on blogtalkradio.com. Now there's 345 podcasts on there, and it's over 180 hours worth of content. And even if you look at the first one, clearly states that there's no loan, there's no loan account, there is no loan. They don't owe you don't owe them a penny because of the securitization, and that the homeowner, there is no, the lien on your property, that it's worth zero or close to zero.
So they don't put.
And it's been called the biggest financial crime in human history. This. and it leaves no room for error. Like I say, I've been going through all of his stuff dated over the last 16 years or so, and it's even stuff that was brought up years and years ago. And that was where I found the point about the things are paid forward. They're sold forward, so the investors aren't buying loans. Because a lot of the points that are put out is that the investors are buying our loans. They're not. They're not. They can't be, because they can't be trading them on the stock market while they're attached to a homeowner obligation.
They need to get rid of your signature.
If you look into all of that, there's a lot of that podcast has a forensic investigator in on it as well, and other lawyers, and they're covering every point. They're covering points on the defence strategy, the whole. I kind of knew. I didn't jump through any hoops with any of this. I just basically put out, right, I knew that a judgment coming forward with absolutely no evidence on their side, well, what would you call that? They have to be able to prove their claim. They can't and they won't, and the reasons why is because it's been securitized and there is no loan account receivable. And I stated to the sheriff as well, assessed her, even under a court order, that loan account receivable will still not be brought forward because it was extinguished under the securitization that they've already admitted to. And meanwhile, I want to know where these transactions have come from and where have they gone to. And then I brought up the issue with the land registry. So that was under investigation out of Ireland as well. I put in documents for that. I put in Australian documents, South African documents.
Can I just say,
can
I just say, as the land registry, do you say that banks still have their name on the land registry when they shouldn't have, because they're not the ones that lent you the money? They've
got themselves listed on there while they've actually sold the beneficial interest, or they say they've sold the beneficial interest, but it has to be it can't be any other way other than a true sale. Now, they'll tell us otherwise, but it cannot be traded as a security unless it's divested of all obligation by any homeowner, because you can't be trading stuff on the stock market while it's attached to a homeowner obligation, because the trading of stuff is going to fluctuate up and down, so you can't have that. But that's what Garfield states as well, and a lot of other stuff I found out of South Africa as well. It can only ever be a true sale. And they've stated in here that if it was a true sale assignment, and like I say, they've confused that with a securitization all the way through, they're totally confused between the points, and they've brought that up time and time again. It's a different process. But again, Garfield has stated that the whole cobweb of assignments transfers from one party to the next, and even when you have like the bank acting as a trustee for an investment fund for certificate holders or whatever, he says all of that is false. It's all just fabricated, false, phony documents. The documents, the paperwork are produced through an AI system, through the securities brokers at the top, using the letterheads of the high street bank, misrepresenting themselves as a creditor, where they're running under this 1970 Act as a creditor, without having the actual rights of a creditor because they're a servicer. So that's fraud. They're attempting to extort homes from people or repayments from people for the benefit of a third party undisclosed, and causing us a financial loss. But the tacit agreement or the deemed contract comes in when we continue making payments, and that's the point they say to me. It's like, well, you've continued making payments and you got this money and blah, blah, blah. And I'm saying, well, show me the origination of those loan funds, because they're not transferred from anywhere within or out with the bank, because it's basically hitting a few buttons on a keyboard to record your credit entry and then calling it a loan, because you can call something anything you want. Like you could call yourself Mickey Mouse, but you're not Mickey Mouse. And that's why I rebutted all presumptions made by any labels, including creditor, borrower, default, arrears, and all the rest of it.
Yeah.
And also the standard security, it's like, right, well, the mortgage agreement, you've signed this, you've signed that. And I basically said, well, it's irrelevant without the corroborating money trail to back it up. So let's see it.
So can I just
Let's
say,
see it as part of the proof of claim, and they can't and won't produce it because
No.
it doesn't exist.
and can I just say, just to make it clear, so you got, you obviously threw a whole load of stuff at them, and then they found out that you were recording, and you didn't deny recording. You said you're recording for your own, you know, safety or whatever. So they took the phone off of you, and they were going to do you for contempt of court. And then they said they were going to send the phone to the procurator fiscal.
Yeah.
And they didn't,
I'll explain
because
it.
if you
They
look
didn't want that information
Yeah,
to go
they
there,
didn't.
obviously.
because the procurator fiscal, it says here, makes preliminary investigations into criminal cases, takes written statements from witnesses known as precognition, and are responsible for the investigation and prosecution of crime. So they didn't want the evidence to actually go there because of everything you had recorded. That's why they didn't do
Which is why I'm pursuing it, and I've already got a complaint in with them about that issue. It didn't go to the police standards. It didn't go to the police standards department, or whatever it's called there. They didn't pursue it. And when I went in a couple of weeks ago and asked about the phone, I was told that the charges had been dropped for contempt of court. And I asked them who ordered for that charge to be dropped, and they said they wouldn't give. I haven't found out that yet. I'm expected to hear back on Wednesday. So I'm going to chase that up. I want to know who ordered for that charge to be dropped, when was it dropped, and why was it dropped. And they told me it was because of insufficient evidence.
You admitted.
And I said it was clear that it was recorded. I admitted it was recorded. And I also stated that I recorded it for my own protection, given the level of disclosures I was making to the court. So there's no denial there. But yet you've dropped a charge due to insufficient evidence. What exactly does that mean?
Yeah.
And I says to them, I am more than happy for you to have a look at this. I've still got the recording.
Yeah.
But the phone was retained in police custody for 3 months. They never got the recording. They never listened to it. The phone never went there. So there's an issue with that as well, because they told me it was going to go there. Nobody told me that the charge was dropped until I went in and asked them. And it was apparently dropped weeks before. And here's the kicker as well. They sent me a message on the seized phone to say that it was available for collection when I didn't even have it. So there's a whole load of police issues going on with this. The assault charge that I made against the sergeant who seized my phone, she put everyone out the court, locked the door. They came towards me and I said to her, you weren't body cam? And they said no. And I said, well, that's very convenient for you. And then she grabbed a hold of me. I says, get your hands off of me right now. She snatched my phone. I snatched it back. And then she tried to say that I would be arrested and locked in the cells overnight if I didn't hand over my phone, which was under threat and coercion of arrest while I was in the middle of an adjournment, protecting my private property against an unlawful repossession, with no proof of standing on their side, no proof of claim, and at the threat of arrest. So anything could have happened after that, because they'd said, but the point I'm making here as well is before it was adjourned, 5 minutes before she asked for an adjournment from 12 until 2, I'd already laid this all out in the court. It was all recorded. And I'd says to her, who would benefit from the proceeds of a repossession, because it's not them, because they're not a creditor. So that point there, 5 minutes later, it was adjourned. 10 minutes after that, the phone was seized.
Yeah.
And it didn't go to the procurator fiscal. And there was a reason for that.
Whew.
So there's that issue there, if anybody can weigh in on that. But I've got it back now, and the recordings are still on it. So I'm going to be pushing that with them, because they'll hide behind, oh, it's a civil matter, we don't get involved in that. Well, anybody with half a brain could look at all of this and see that it's very much criminal, because there's fraud, and they don't like that word, but there's fraud, there's perjury, there's there's non-disclosure, there's breach of contract, there's unjust enrichment, there's theft, or there's all, I mean, it just goes on and on. And in the US, these cases are being tried under the RICO Act, which is Racketeer-Influenced Criminal Organizations, which is, well, racketeering, and it's on multiple levels with multiple players with an undisclosed securitization scheme involving the land registry, the banks, everybody involved. And then you've got to look at the conflict of interest and the heavy court bias. And again, it comes down to that statement she made, where if I succeed, a great percentage of mortgages and loans written across the globe should be set aside.
That's why they're not going to allow you
assignments, or in the case of securitization, which happens in every case, which I've learned, there's no dispute about that as well from what I've learned. It happens, it has to happen. No loans would happen. The securitization wouldn't happen without the issuance of documents from us. And the alleged loan wouldn't happen without, it's like a codependent thing. You know, so that's where you get the reformation of the two contracts coming in, and the whole thing being taken as one contract. And then the promise to pay from us, once it's converted into a security with the paperwork, becomes the promise to pay from us is extinguished, but then it becomes a promise to pay through the insurance companies and through hedging, through the trading, the credit default swaps and the mortgage indemnity insurance, which would have kicked in after 90 days of non-payment. Now, if you look at the payment holidays during the lockdowns, 3 months payment holiday, and then another 3 months. At what point did the indemnity insurance kick in?
Oh, God, yes.
So there's no party anywhere within a securitization scheme that has endured any financial loss. They've got no skin in the game. It's all profit at our expense, and we're being chased for repayments on alleged loans that were misrepresented. There is no loan account, and nobody holds that loan account anywhere, which is why they'll substitute the mortgage statement in its place. And that statement, the origination of it is not known. It's done through AI, through the securities brokers, using the high street banks as a conduit, as an admin servicer, receiving a servicing fee. And then under a DSAR, when you apply for a DSAR, they're getting it from another source. It's not coming from them because there's only a servicer. It's coming through them. But like on this internal listing with the over 600,000, and they can't tell me where those funds have originated from, because if they told me the truth, then you would start to say, well, what if they got to do up top the investment bank, they don't have lender status because you don't want it? Why am I getting payments from them? And what if they got to do with my specific transaction with that high street bank? So I want to know, where has that transactions come from, and where have they gone? And why do they not show up on the customer statement? Because that's an omission. It's concealment, it's omission, and therefore that mortgage statement is incomplete. Also, because the bank is acting as a servicer, you would expect to see payments going in and then being dispersed to a third party. And where are they getting the defaults from? Because if the loan was extinguished at the beginning through securitization, which they've admitted to, you can't be in default of a loan that doesn't exist and it's already been settled. So that default amounts are manufactured, and they're sticking them onto the mortgage and then applying interest to them.
So someone's mentioned the Carmel Butler memo.
Oh yeah, there's points about that as well that was raised up. Right, first of all, there's mistakes throughout this whole judgment. She states there's 5 transactions in that internal listing, right? But it's 8, so it's a mistake. So again, I had 3 judgments sent out due to errors and corrections, so there's an issue with that as well. So it makes it incompetent or suspected to be incompetent. The Carmel Butler, I'm just going to see what she said about that, because I put in that as well. And what she said was, let me find it just a second. She called her Caramel Butler, by the way, so it's another dodgy thing. Here we go. Right.
Caramel Butler, that's great.
She, as in Carmel Butler, she perceives there to be a secrecy in the process and voices concerns about whether the balance sheets of banks show the true position, particularly so far as ownership of legal charges is concerned. And what she says is, this is one person's opinion and has no legal standing. So to be questioning what they're showing on their books, and there's an auditing ruse, and there's also an accounting ruse where they're not following GAAP principles, the generally accepted accounting principles, but it's now called something else, and I've forgotten what it is. They're following some other thing. But basically, if they're not going to show the true accounting, because then that would be exposing the fraud. So they're misrepresenting it as a loan, where if they represented it the way it was, like you're issuing valuable instruments that have cash value that you can then securitize for massive profits, they're avoiding taxation on that. So there's a tax avoidance. And another thing as well, apparently the SEC are welcoming whistleblowers that are exposing securities fraud. So there's that as well. There is that through the SEC, because it is securities fraud, because they're drafting us into this scheme while excluding us from any of the profits,
yep,
and then making us believe that we actually got a loan. So this is her opinion. This is one person's opinion and has no legal standing. So she's picked up on that point, but she's failed to go through any of the rest of the points on it. And like I said, she says that parts of the stuff that I put in do have merit, and I want to know what bits does she think has merit, because I could go with that and then say, well, if you're agreeing to this bit, this ties to that, and the next thing. So where are you going to go from here? Yeah. But then it comes down to they have no proof of claim on their side, but yet she's entered a judgment.
So
that can't be right.
No.
That's just happening to everyone.
Absolutely. So is it reasonableness? So is this her judgment here? Can I just sort of end on that? And then we're gonna, so she says, this is the judge on reasonableness. It remains therefore for me to consider whether it is reasonable for me to grant this application. And as set out above, the 1970 Act provides that I am able to take the following into account: the nature of and reasons for the default. The nature of the default in this case has been a deliberate act on the part of Miss Shell not to comply with her contractual obligations under the standard security and mortgage loan. And they say it's a security there. And the reason why she made that decisions are set out in her defences and counterclaim and in her presentation to me at court in May. Again, as set out above, I do not consider anything that was set out there provides a justification, good reason, or indeed any basis for her failure to comply with her obligation. So quite simply, Miss Shell is in the same position as every mortgage holder in the UK, across Europe and the USA who has borrowed money to purchase a home. Indeed, it is not only mortgage loan, but in fact every sort of financial transaction in the economy that is subject to securitization. So she's admitting that they do get securitized. Student loans, car loans, lease agreements, credit cards agreements, aircraft leases. She's admitting even more intangible sources of finance, such as milk quotas, can be securitized. If Miss Shell's arguments succeed, a great percentage of mortgages and loans written across the globe should be set aside. So hence you are not going to succeed. This in itself does not inevitably lead to the conclusion Miss Shell's arguments about securitizations, to the conclusion, and your arguments about securitizations are baseless, but it is a further very strong indicator when the arguments are advanced absent any legal basis. So the ability of the debtor to fulfill within reasonable time the obligations under the standard security in respect of which the debtor is in default. So Miss Shell made it clear she had no intention. In fact, she considered herself entitled to remain living within this property without having to make any future payments to the pursuer whatsoever. Indeed, in her counterclaim, She asked the court to make any award to her in the sum of over 650. She did not put forward any reasons why. Well, the fact that over 600,000 went through your account could be one reason, and you've got evidence of that. She was unable to make...
I'll stop here. I'll stop you on that point as well, Laura.
Yep.
That is completely fabricated about me demanding 650,000, because the point I made was, and still am, where do those funds originate from and where have they gone to? Because they may be credit payments due to the alleged borrower as part of their share in the undisclosed securitization scheme. And I put in a document stating that there could be credit payments due to the borrower as they're a creditor or investor unknown to them within an undisclosed securitization scheme. So she's turned that around.
Twisted that.
What I stated was I would be due in rescission, possibly that for harm, loss and injury, financial loss, emotional loss, loss of earnings due to having to spend... A lot of people are having to spend full-time hours researching all of this stuff because it's really in-depth. You've really got to dive deep to find out a lot of this information. So in my case, it's affected my income, my ability to work, and all of that. So that should be... And you know, that has come down from them being... hiding all of this information and not telling you the truth, because as far as I'm concerned, as soon as I brought this issue up, it should have been addressed, and it's been dragging on now for nearly 4 years, and I know a lot of people have been going a lot longer, and they're not going to give you the information you ask for. So at the end of the day, they have insufficient evidence on their part, and yet they're still coming after this. And if you're looking at it from whatever act the bank is moving under as a creditor, when they're not a creditor, when they go to these evictions and stuff, all of the paperwork they're using from that is going to be based on their status as a creditor with the rights to repossess when they're a servicer without the right to repossess.
Yeah.
So that's another point with that as well. So it's all fraudulent all over.
She's gaslit you. She's twisted everything. So she did not put forward any reason why she was unable to make any payments. Yes, you did. Fraud.
Yeah,
rather she chose not to make any payments, and she had no intention of doing. She did not consider herself bound in any way to do so. Well, right. Any action taken by the creditor to assist the debtor to fulfil these obligations. The pursuer has averred that it took these actions, and the defender has not denied that opportunities were given to her to resume payments. It is clear from the correspondence that was lodged at court between Miss Shell and the bank, High Street Bank, that she made it clear to them she had no intention to pay, did not consider herself due to pay, due to a deliberate intention rather than any inability. How can they say this when you're arguing?
I'll stop you there. So basically they're saying that I'm due this money, and I'm like, well, they're not a creditor. They have no rights to pursue me as a creditor when they're a servicer. 2, there can be no default on a loan that doesn't exist due to securitization, which was extinguished, and they can't prove their claim as a holder in due course. The next thing, I made it clear that I was put in this position, like a lot of other people, due to the fraudulent lockdowns and the fraudulent pandemic, which was part of the engineered thing to put people into this position as part of an asset grab. But I mean, that's not up for dispute now. We all know about that. But the point is, if you're put in a position where you're forced to lock down, you're not earning any money, you're not being able to cover the mortgage, then that right there is your inability to pay. And I made that clear to them time and time again. And it was during this time that I started researching, that I'd found out about all of this stuff. So who in their right mind, and it's also, if you continue, here's the thing as well, if you were to continue paying, knowing all of this stuff, they'll use it against you. And it's like, well, if you're saying all of this, then why are you still paying? So it's either way you're stuffed.
Yeah,
so if you know, and I am 100% clear on all of this, there's no doubt in my mind about any of it, not even a tiny little doubt. what I've learned. But yeah, it's twisting words, it's
absolutely,
gaslighting,
absolute
it's
gaslighting.
Failing to comprehend
And
what's being said, you know.
I bet she was sweating behind her gown.
Well, I brought up the Credit River case as well when I was in court, and she actually looked it up on her computer. Now, this was an old case out of the US. I think it was 1968, 69. The Credit River case. Now, I know a lot of people would have seen the video. It's quite confusing to follow, but there was a video made of a kind of a reenactment, and it's the guy in court questioning the bank, saying about the promissory note and if it has cash value, and they go back and forth, and it's established at the end that that promissory note, or the first document that you sign, has cash value as a promissory note. So if you hand that over, the record of what you think of as a loan, and it's falsely portrayed as a loan, is a record of that credit entry in your account, which then gets purchased from the top down and converted into a security. And what happened with that case was, I think it went through before the Supreme Court, I had to check, and then there was an appeal, and they still upheld it because there was no consideration paid. And then a few months later, the judge ended up dead in suspicious circumstances, and apparently that case still stands now on a point of consideration, and that the banks don't lend money. Also brought up Professor Richard Werner's stuff, where he states that the banks do not lend money, they're in the business of purchasing securities. And I put in another document with that, along that lines as well. And she just, what was it she said? It has no legal basis for that.
Yeah.
And it's like, well, at what point does an expert witness or an expert testimony on something have to have legal authority to approve it? You know, if they go under interpretation and stuff, how can they turn around and say, oh, it doesn't have legal authority? Well, why is that? Is that because there's a heavy court bias against us and for the banks? And to admit to that and to say it's true, well, what would happen then? So the other point she's saying is that people have brought forward all sorts of similar arguments to mine, but none of them have prevailed. And why is that? They should have. But then if you look at the Garfield stuff, he says he's won plenty of cases, and he says homeowners are totally confused as to why they won, because they thought there was no way to win, because they allegedly believed they got a loan, they stopped paying, they couldn't afford to pay, and that should have been it. And he states that 98.5% of people that are challenged with repossession or foreclosure won't even challenge it because they believe the lie. 98.5%. And he says, and of those people that do challenge it and chase it all the way, going for proof of claim, it is usually struck out for insufficient evidence under a non-disclosure agreement, and the court record is always struck.
So what do you think is going to happen to your case? Because they're not doing much of that here, are they?
Well, I have an appeal in, but like I said, I'm not going to be I know that they make it complicated, they make us jump through hoops and stuff, but I've got all of this, and I'm going through the Procurator Fiscal as well. I'm going to try and see where the phone issue comes up.
Yeah.
But I think they have no evidence on their side.
But you're in the wrong call.
They have not one scrap of evidence to support their position. They've also admitted that those are the proper documents for the say they're a servicer, which makes them not a creditor. So therefore, they're not allowed to go under the 1970 Act to repossess. So they've admitted all that already. So the only other thing open to them is to negotiate a settlement. Because the sheriff has stated here that if it was a true sale assignment, then the whole thing would be void ab initio from the start. And it should be struck out. Well, what bit? I mean, there's nothing here. There's absolutely no evidence or nothing. Indemnity insurance is another point. I want to know who benefits from that. When was it paid out and how much? So again, if you've got 100,000 mortgage and they've maybe insured it for 150, you've got an issue with that as well, because that's another element of fraud on the insurance company. And if they're not if the bank wasn't the beneficiary of that, then that meant that they were never entitled to receive that proceeds, because they've not lost any money, because they didn't loan any money, because they're not a creditor, they're a servicer. So there's all of that. The transactions coming through, the 600 odd thousand.
Yeah, I mean, how can over 600?
Gone?
Yeah, over 600,000 it comes in and out of your account.
Yeah, so, 8 different transactions. So it's coming over a period of time. One of them, two of the transactions were like 5 days apart. And I got the mortgage. They said again, oh, you got another remortgage. I changed product to a different rate. And 2 days later, it was securitized again. And they said, oh, you got this loan, you signed this. It says, that's irrelevant. It says, and they said, oh, but you've been paying all this time. I says, yeah, and so does everybody else until they find out the truth.
Yes.
So when you start digging or asking questions, they're not going to tell you. They're refusing to answer your questions, so then it puts it into dispute. So with anything else, if you're asking pertinent questions, they have a fiduciary duty to be honest, upfront and clear with all their communications. And all I've had is lies.
Yep.
Total lying about everything.
Well,
refusing to supply documents, all of that.
Yeah,
you know?
What they're saying is, and this is something that I've noticed with the cases that I have been to court when it comes to mortgage, what they're saying is it doesn't matter what's going on in the background. All you need to worry about is you signed the agreement and you need to pay. That's their bottom line, is that. And and they don't want you to investigate. They don't want you to ask questions. And when you do, they say to you, don't worry about that. None of that matters to you. It's irrelevant. You don't need to, lose sleep over that. You just carry on paying like a good little soldier.
Yeah. Paying for what?
Yeah. Miss Ross.
I know it's ridiculous. Really bad. And the thing is as well, I mean, getting back to this point, they're making a claim against the All Caps name. Now I'll just touch on this. They're making a claim against the Legal Fiction All Caps name, which is not us.
Yeah.
But the harm is being done to the living man or woman.
Man or woman, that's right, yeah. So they're saying...
And they're a corporation acting against the legal fiction, but it's the living man or woman that is suffering
deprived
the loss, or including the loss. So again, there's that issue, but I won't go into that because it's
a whole different story, yeah. So she then goes on to say, Miss Shell stated that she was aware of the case of Stamp. They do like to bring Ian Stamp in the mortgage scandals, but sought to distinguish her case from arguments that he had been presented there. No reasonable distinction could be made. It was therefore a great surprise to the court that, having spent so much time on studying this matter, she drew no guidance from the legal authority that did exist, choosing instead to rely on material previously rejected by the courts. This is not a reasonable way to conduct litigation. No further valuable court time should be taken up with this case. High Street Bank should not be put to further expense on the basis of the pleadings she has presented to the court.
In other words,
I find the defendant's answers to the principal claim plus the counterclaim are fundamentally irrelevant and misconceived. So, even though this judge admitted she actually doesn't understand this, how can she give a pleading when
the way through? All the way through, she's stated time and time again, well, I'm not clear on this point, I confess I don't understand this bit, confusing this in the assignment, the securitization all the way through when I've clearly stated it. And I've also got exhibits in from the bank stating that it's never been assigned or transferred, but it has been securitized, and she's failed to recognise the difference between the two, despite all the information. I put in mountains of information. And I asked her in court, I said, did you read the stuff I put in? I had a look last night, and I'm like, right, hundreds and hundreds of pages last night.
Yeah.
He says, well, what bit did you not understand?
All of it.
And it was actually a heated argument. And actually the security guy in the court was coming towards me at one point. She left the court for 15 minutes and she came back, and I spoke freely for an hour and a half, and I covered every single aspect on all of this, and she knows it.
So
she knows it. I put out everything. I covered everything.
You need to go to higher.
And then the other side got to talk, and he came out with stuff, and then she went back to me. It was adjourned for 2 hours. I went back in and spoke for another hour and a half after that, and I covered everything. And then she went away for May, June, July, or 3 and a bit months to look into all of this again. She came back with this judgment. It's like, how the hell can you do that? Because clearly there's definitely some sort of court bias here. Well, we know that there is.
Yeah.
There's no way that she could have looked at all of that evidence I put in, all the documents, everything, and come back with a judgment against me. So, I mean, there's clear
there's not enough
investigation. Clearly.
Yeah, they're not doing it. There's an investigation that needs to be done, and then the investigation's not done. She said, I find that the defendant's answers to the principal, I've read that as have I. For the avoidance of doubt, all of the defendant's preliminary pleas are repelled. As stated above, Ms. Schell is entitled to her strong views on securitisation. I suggest that
not just my views.
I suggest that if she wishes a change in the law, she should direct her concerns to her member of parliament.
Right. No, it's laughable. I mean, even the Garfield stuff, he says there's the SEC, the Federal Reserve, and everybody knows what's going on behind the scenes with this. And nobody's taking any accountability. But it's causing real world harm to people, including, I mean, there's multiple reports of people committing suicide due to this. So it's not a laughing matter. And also the fact that they're not demanding any proof of claim on the other side. Now, if you look at any case anywhere for anything, it's a precedent towards any action or judgment that you have to have proof of claim from them that are making the claim. Where is it? They don't want to look at it because, again, like I said, if I succeed, a great percentage of mortgages and loans written across the globe should be set aside. So she can't be saying that.
No,
and then at the same time saying that she said my claim was risable, RISIBLE. And I looked it up and it was laughable. And it's like, yeah, you're saying it's laughable and that it has no merit or any of that. But at the same time, you're saying that. And also, I've got proof of corroboration between the Financial Ombudsman Services, the bank and the solicitor collaborating between them to say, how should we answer our questions because we don't even know where to start. And then the bank had come back to their solicitor and said, just tell that her claim has no merit.
Wow.
And then the Financial Ombudsman has come back and they've admitted that they don't have a remit on securitisation, which is always under a true sale, right? Because of all of this stuff I brought up. And they've come back and said, we don't have a remit on securitisation, which means that it's not something they look at or they take into consideration, but we're confident that the bank can repossess. And it's like, well, that's what? It's totally contradictory because the securitisation extinguishes any obligation under a true sale. And at the same time, he's saying, yeah, you can go and repossess. So you can't pass that judgment while you don't have a remit on the very thing that extinguishes the obligation in the first place. So there's collaboration between that lot. So I pulled them up on that as well. And in addition to that, they also sent me an email I got under DSAR stating that none of her questions should be answered and we should just stick to the narrative that her claim has no merit. Now, that is them collaborating against me, and the Financial Ombudsman also turned around and said, we won't find in her favour, but we'll just go with every other previous case we've brought up. Now, I put that in as well. So you've got a problem with that as well, because they're just gatekeepers and they're keen to raise complaints all the way. And then those complaints are just railroaded over. So the issue, there's issues all over this. And like I said, these cases are being tried under RICO, the RICO Act 1970 out of the US. And then they tried to say, oh, that's in the US. And I said, well, actually, because it involves international banking, in the SEC, you're looking at international banking. So there is no, you can't separate it from this country, surely, because the transaction involved with my transaction in the securitizations, another jurisdiction. So there's that as well.
Someone's,
So I'm not sure how that works.
Marcus just said that going to the ombudsman is not really going to achieve much. They're funded by the banks and have no lawful or legal standing. It's another distraction, illusion, or do you know what? Every single corporation just seems to be just they're just narcissists. They're it's awful.
It's totally narcissistic. It's causing harm, loss, and injury to people. It's causing a huge amount of financial stress. It's breaking up relationships, destroying businesses, and it's an attack on men and women by a corporation that are going under our legal fiction, all caps name.
Yeah. With
the true world harm happening to the man or woman, a living man or woman. So there's that as well. But I mean the current. It's just, I mean, this is what we're all facing here, and there's got to be some sort of breakthrough somewhere. But like I say, it's
right. Can I round it up because we've been on here quite some time? Does anyone have any questions before this wonderful, amazing lady goes? What I'm going to do, thanks to Marcus, I've got here as well. You know I'm getting tired, right? Because I'm actually trying to use my mouse to move my phone where it's actually dealing with a computer. So you know I'm getting tired, right? So Marcus, thank you for the links that you've put all over the thread. If you could send them to me, I'm going to attach them at the beginning of at the heading of the live. So if anyone sent me any links that can back up everything.
Okay, it's okay.
Yeah, go on.
Just another point as well. Right, if indeed the contract with the pursuer was void ab initio, that would be a complete answer to the case if it should succeed. Therefore, the other arguments regarding the effect of a non-disclosed securitization process post-contract are in fact ESTO arguments, falling to be considered only in circumstances where the first argument does not succeed.
That's
so basically saying if it was seen, if the contract was void ab initio, which it is because it was there was no loan, it is void.
Yeah.
She's saying the rest of the arguments I'm making falling to be they're secondary to that first one. So she's saying if it was void, then that should be a complete answer to the case, which it is. She's admitted that as well. On top of that statement saying if this was to succeed, then they would all be struck out. So it's another disclosure there on our part. That apparently the whole thing is laughable, apparently.
Yeah.
So you can't be making statements. It's total polarity from one side to the other. You can't be making statements like that and then say, "Oh, it's laughable." So she's,
I've got Richard Romanis. Laura, there is much more to this than people are told. If you would like to inbox me and explain, maybe we can talk about it. Jury said, I advise you obtain the investor's prospectus that the lender issues for the year completion took place. It has all the info. Do you know what that is?
What's that?
Investor's prospectus.
Is that the pooling and servicing agreement or the bond issue? That because what I've learned about that is it's a document for something that may happen in the future, but that hasn't actually happened. It's not a record of what is actually happening. That's what I've learned from Garfield as well. So it's the whole pooling and servicing agreement is something that's likely to happen it hasn't necessarily happened on account that they're not buying actual mortgage-backed securities because they've been extinguished through securitization, because the investors are not buying actual loans. That's what I learned from that as well.
Okay.
On that.
Right. To recap, because we're gonna go now, because it's two and a half hours we've been, which is great for me. I love talking, but you know, please share this live because it might help someone who's dealing.
There's another point that I think is quite important to bring up as well.
Yep.
Okay, and I've looked into this. Right, page 22. The solicitor for the other side provided, albeit ex parte, so I looked that up, and it means that she's consulted with their solicitor without my knowledge.
Yeah.
Right? And apparently these was on the payments based on the 600,000, and what he was saying before was that those payments were made depending on when the mortgage was in arrears or not. So the mortgage was taken in and out of a pool, and I'd already blasted him down with that as well, because he spoke about that in court, and then she put it back to me, and I just says to her, that's totally ridiculous. I don't know where you're getting it from. Like I said, you can't scramble eggs and then unscramble them and stick them back in the shell, or that sort of thing.
Yeah. Because
once the mortgage is entered a pool, there can't be the looser mortgage status. So she's consulted with him without my knowledge, ex parte. So I've also brought that up as well, that I should know what was said, and I haven't been told what was said about that.
Right.
So that's another point itself, but I'll finish there.
Well, they are talking together, and you're not involved in their conversation, which is. So what are you going to do now? You're going to, because obviously
I've got this appeal together, but like I say, I'm not going to be jumping through hoops. I'm not sure, to be honest. I'm putting in this appeal. It's due at the end of this week.
Okay.
I try to go for. I've got all of this here. They've got no evidence on their side. They've given me loads of admissions and stuff. They've admitted to things. They can't be moving under the 70 Act as a creditor because they're not. They've admitted that as well.
Yeah.
The securitization funds, they can't account for that. So I'm going for a strikeout, ab initio, void ab initio, and to negotiate a mutually acceptable negotiable settlement. Otherwise, this risks being investigated, which I'm hoping to go through the Procurator Fiscal. I don't know how that's going to work with the phone issue, but the hide behind it being a civil matter, but if you look at all of this, it's definitely criminal, and it needs to be investigated as criminal, and they can't keep hiding behind a civil label, you know, calling it civil when it's definitely criminal. So it needs to be investigated.
So someone's just said,
if it does get investigated, it risks setting a precedent. So
exactly. So someone just said you can only do a mortgage audit via the US. The UK has not got the right credentials. Okay. So maybe that's something
that could bring the whole lot in under Reformation, because as Garfield says, the Reformation taking our mortgage account, the misrepresented loan, along with the undisclosed securitization scheme, which goes international, usually out of the US, so one of the big US banks is the investment banker or the securities broker, then it would take that in as well under a full securitization audit in Reformation.
Yeah.
And she stated as well that without the full audit, that she's got no way of being able to clarify things. And my point with that is, well, without that, you can't be passing the judgment because you haven't got full information. How
can she pass judgment?
And therefore, there's insufficient evidence. So what are you doing?
Exactly. And, you know, so bear with me because I've got one here from... No, they just disappear. Marcus, when you said ex parte discussion, it could be another reason for appeal, maybe malfeasance in public office.
Yeah.
So, yeah. Right.
I've stated that I've put that in my appeal as well. Yeah. I
Well,
want to know what was said.
you are doing amazing, absolutely amazing. And we done a discussion. I'll tell you what I'm going to do, which is kind of probably similar, but I will try and find last year's. I don't know if I can. It's in there somewhere. But there was a discussion we done last year. I will try and put it on in the heading if anyone wants to go back and watch that. But I think it was last year. But since then, you've literally have come on so well with all your knowledge.
I think I was just jumping it needs a lot of jumping around explaining everything because it's so complex. I mean, you've got to go through certain things to be able to explain other things in that. And I think before I was just jumping about too much and repeating myself a lot. But
well,
yeah, it's just what I found in getting this judgment because I kind of knew, I thought, there's no way she can enter a judgment against me. But this is what's happening to everybody. I know
everybody,
that.
Yeah, everybody.
Because there's no evidence. There's no proof of claim.
But what you've uncovered...
And she hasn't even brought it up at all, anywhere.
But what you've uncovered, I mean, there's so much yesterday when we were talking that was blowing me away. And when you said that they are purposely engineering mortgages to default so that they can... make money on them. I mean, this is what they're doing with everything. Everything has been cleverly set up.
Well, you've got the pandemic, you've got the cost of living thing, you've got you've got the multiple interest rate rises, you've got everything that they're doing just now under this whole Agenda 2030. You've got the motoring things, you've got ULEZ, you've got everything that's putting people into financial distress. You've got companies and businesses closing down everywhere, higher rates of unemployment, the whole lot. It's all going to contribute to people not being able to pay their bills or mortgages, and then they're going to be faced with repossessions or being in default, apparently.
Yep.
Being in default, falling behind, repossessions, being unable to remortgage or whatever. And every time you remortgage anyway, it's a fresh round of securitizations. So it's profit all the way.
For them.
Unjust enrichment for them, putting people, squeezing them financially, and all of it is due to an asset grab. Well, look at the illegal immigrants coming in and they're being involved in all these repossessions and things, and getting everything paid. All of that, you take all of that into account, and it's all part of a massive engineered default. And meanwhile, no one's losing any money. Everyone's making massive amounts of profit. There is no loan account. There is no loan accounts being paid down. It's all profit. Properties are sold off cheap to all their friends and acquaintances. That's profit. And then all the money goes upstream to the top of the pyramid to the investment brokers, banks, whatever. And then all of that money is offshore. And then you've got the whole thing with the investors. That's money laundering coming through that. I mean, it's just a total shit show everywhere you look. And it's just... it's got to come to some sort of head sometime. But,
it has to,
again, these courts, there is no legal system. It's just entirely corrupt from top to bottom.
Exactly.
And it's restoring.
And do you know what I found? Do you know what I found really interesting? What you said, and it absolutely makes sense, is that when they securitize a mortgage and then it becomes securitized, and it goes into a big sort of whirlwind, if you like. They can't put it in there with your details. So they have to separate you and the mortgage that is you from the securities. So therefore, there is no mortgage.
They're not selling any loans. They're selling the data points connected to your loan or your loan transaction, which wasn't a loan. They're not selling any actual real world loans because there isn't any. They don't lend any money. That's it. We're led to believe that they do, and until people, I think a lot more people are aware of this now, but it's the courts. It's like it is narcissistic abuse on the courts.
Yes,
it's gaslighting. It's denial of all of this, and no matter how many of us come forward, thousands of people. And like I say, I got a lot of this info out of South Africa and out of the US, and I would say to everybody, get onto that Garfield site and just watch it. And there's loads of interviews, there's loads of stuff back from like 16 years ago, and a lot of the older stuff is really interesting as well. There's a whole series of videos on that, and it goes into the whole how the whole thing works forward. You know, they sell them up front, they sell them at the top and then fulfill the orders from the bottom up. So if you're doing that, if you take it as like a one-off, they sell it up front and then they fill it in from below. It's part of a giant Ponzi scheme.
It's just
and
crazy.
If the only way they don't care if the homeowners make payments or not. It doesn't make any difference because they're making that much money with no risk, no counterparty risk because it's been eliminated or is no risk to them. But
yeah.
As long as we keep believing that we're getting a loan or this is what we've applied for, we're getting a loan. There's also another part as well. Apparently out of the US, the appraisers, or what we call the valuation people here, they were told between one house sale and the next house sale, they've been told to elevate that amount in order to provide more profits up top. But I would say to people as well, if you haven't seen it, go and watch The Big Short. It might take a few watchings to get it, but they go into credit default swaps and all the AAA ratings, or they're giving ratings to mortgages that is like AAA as a tranche when it could be just total crap that's in there.
Yeah.
But they're giving them a higher rating so they can demand a higher amount from these investors. But remember, a lot of these investors aren't investors; they're a conduit for money laundering. That's another thing that's been brought up. I've got an Australian document that I came across. It's 83 pages long, and it goes into that in quite a lot of detail. And there's a glossary at the back. And the first point of that glossary they've got is Neil Garfield to go and look up.
Right.
So it's The Big Short. If you watch it, you'll suss out what's happening with the credit default swaps and the AAA ratings, and it tells you all in there what's going on. There's another documentary called Inside Job.
Yeah.
And you can see it's a documentary. It's Matt Damon that's narrating it, and it's quite interesting because you see all these banking people high up like Ben Bernanke and all of them, and they're just dismissing accountability for all of this. It's all about the 2007-8 crash, but they blamed it on a homeowner for taking out loans that they couldn't afford. But the reality was that they were throwing loans at anybody that could sign their name.
Yeah.
Because the purpose of it behind it was to benefit from the credit default swaps when they knew they would fail, but the homeowners got blamed and they made all the profit and they were bailed out at the top when they didn't need a bailout because they were making so much money.
That's just crazy.
And then the homeowners were left to take a fall.
Yeah.
So that was what the real part of that was, but they blamed it on the bottom, the homeowners.
Right.
But there's loads of documents that I've come across that I'm happy to send them to anybody that gets in touch.
Oh, well, thank you.
So you
well, I would have to, if anyone wants to get in touch, please, because do you really want to give out your Facebook? I mean, I don't know. Message me privately, and I
can pass them on to you.
Yeah, and Cheryl can pass them on to me. Right, we are over 2.5 hours. Before I go, there is a video that I was watching the other night. It is a long video, but I found it really quite mind-blowing because it does talk... Which one?
Aye.
It's called...
Is that
the corporation?
The corporation.
Yeah, and I was like, so if you go... I think it's on YouTube. It is. It's called The Corporation feature documentary, and it explains... I mean, literally, it was mind-blowing. It's 2.5 hours long. No, 2 hours and, I don't know, 2.5 hours long, I think. I started watching it. And this is what, it was amazing. And it explains that even some of the CEOs in the corporation had no idea what was going on until it kind of hit them. And they're like, whoa, they're part of one massive narcissistic agenda. And that's what we're facing. Yeah. So it's really important that, you know, we share these videos, we talk, we get people to try and understand this. And obviously Shell's been on this journey for a long time. People like me have not sort of really delved into it as much. But right, we're going to finish it there. Please send me any links you want me to share. I think Marcus is going to send me some link. He's put some. Go back and have a look at the questions as well, so you can read everything for yourself and the comments.
Will do.
Yeah, and
I'll find some stuff and then send it on the information side, just so people can read it and understand it more. It is really complex, but like I said, I can pick out stuff in documents that are not quite what I'm picking up elsewhere and stuff, but I can just take it all into account and then see where it makes sense and not. But it's still, I had a few real light bulb moments, but it just dropped everything in for me. But I can see some of the thing is, if you look through a lot of these documents online, it's quite hard to find whistleblower stuff that's telling you what's really happening. But like I say, the Garfield stuff, now he did it was a 5-day, what do you call it? Is it a deposition or something? A 5-day investigation through Wall Street, and I think it was involving a number of banks in law firms and stuff. And as he stated, that he's been called a crank or a conspiracy theorist and all of this, but then you've got to ask why. Also, he says that not one single person on Wall Street has ever come back and said that he's wrong about anything ever. And he was on Wall Street in the 7 case when they started up securitization. He was basically in the room when they started it up. He did it, and then he drew back from that, and now he's working on this. Well, he was working on the side of the homeowners because he died last year, age 76. But I would say anybody, go and check out that. Go and check out that blog. What was it? blogtalkradio.com, the Neil Garfield Show. And there's pages and pages and pages of podcasts. But even if you listen to a few, you'll see it.
Okay, brilliant. Right.
But there's heaps of information if you find the right stuff.
Brilliant. Thank you so much. Right, bear with me. I'm just going to end this. Thank you so much, everyone. I hope you've enjoyed this. Please share it with anyone that you feel that it might benefit. And I will see you again actually tomorrow evening, I think. Oh, I can't remember now what time. I'll put a status up, but I'm back on here tomorrow with Dave Murphy talking about mortgages. Thank you, everyone. Much love. Mwah. Ciao.
Bye.